All right, guys, welcome back to another edition of Lawyered Up. I am your host, Jared Moore, and as usual, if you guys have questions, you can pop them into the chat. We've already got some stuff in the chat going from before the stream started, so I'm going to try to answer them, but as you guys know, I'm not a lawyer, and I'm just wading through this as usual with you guys. Today, we're going to talk about a case at the Creek Nation Supreme Court that is affiliated to the Grayson case. So just a quick recap for you guys. The Grayson case, there was some legislation that was passed because two Supreme Court justices recused from the Grayson case when it got to the Creek Nation Supreme Court. And the legislature and the executive branch felt that they needed to appoint two special justices with the rationale that there would be enough justices to have a 4-justice majority opinion. So that's where, then there was a challenge to the constitutionality of those legislations, and that led to that challenge going to the Supreme Court, and all the other cases were stayed. So I'm going to go ahead and pop the browser up on the screen, and we will start going through this. I've got some interesting things to point out, or I think they're interesting. There are links to everything I'm going to show you guys in the description of this video, and I'm going to show you how to navigate there for the ones that aren't hosted on our Google Drive. But speaking of the Google Drive, the first thing I wanted to show you guys is if you go to Creek Supreme Court here, you can click Current Docket, right? And you can see what we're going to be discussing here is SC-2024-05 in the matter of the Constitutionality of NCA 24-077, okay? And if you click that, you'll see there's some briefs listed here. But before we get into the briefs, I wanted to talk about the order assuming original jurisdiction and docketing the case, because this also points out some interesting things and sets the schedule for these briefs to be submitted, which is going to affect for us when we see them. So the first thing I wanted to point out with this order is that if we're reading through here, this says that, where is this part? I just want to back up a little bit. In the above styled action, both the timing and separation of powers elements are present. The law in question directly impacts the timing of all current and future Supreme Court actions in which a justice is required to recuse pursuant to the nation's judicial rules of ethics, of which there are currently 2 cases on the court's docket that are now stayed pending resolution of this matter. Now, the reason I wanted to mention that is if we look at the list of the current docket for the Supreme Court, right? There's 2 cases here. One of them is the Grayson case, which we mentioned is stayed. And then the other one is the one we're looking at, which this order is the order setting the schedule for this case. I don't know how this is included in the 2 cases. Like, there might be another case that I haven't heard of or seen out there related to this that's been stayed, in other words. So just keep that in mind. It's just a little point that I noticed while I was going through this. The next thing I wanted to point out in here is that NCA 24-077, right here, this is the law that's the constitutionality of which is being challenged. And this is the Supreme Court has written this order, okay? So here's what they say. NCA 24-077 adds an additional 120 days that an appeal may be stayed pending appointment of a special justice by the principal chief and national council. Furthermore, MCNCA Title 27-3-303, as amended by NCA 24-077, makes the law specifically applicable to writ of habeas corpus, directly in conflict with NCA Title 27, App 2, Rule 27, which requires complete resolution of a habeas corpus action within 72 hours of receipt. What am I talking about? Okay, so what the Supreme Court's saying here is they're giving the reasons that they've assumed original jurisdiction for this case, that they're going to hear this challenge. And what they're pointing out specifically there is NCA 24-077 amends some time deadlines in relation to responding to habeas corpus requests that conflicts with Rule 27, which says that those have to be done within 72 hours. So they're saying at a minimum right there, that's a problem we've got to fix, because we can't have conflicting deadlines for habeas corpus. Okay, let me go back to where we were. The next thing I wanted to point out is that they also make a claim down here, and this is the Supreme Court's writing this. These aren't the lawyers involved. This is the court. The judicial branch has been effectively removed from its role in making temporary appointments to the Supreme Court under MCNCA Title 27, App 1, Rule 15A, a law which previously required joint approval by the Principal Chief, Speaker of the National Council, and Chief Justice of the Supreme Court for any temporary appointment to the Supreme Court. So what are they saying there? They are saying that previously the rules were if there was going to be a special justice appointed to the court, the Chief Justice of the Supreme Court would also have input on the person that is being put on the court, right? And the new law removes that input. That's an important point to go forward. We've got a request here to explain habeas corpus. I'm going to do that real quick. Try to. So, I don't know if you guys could see that. Let me zoom in. This is from the dictionary. Pretty simple. A writ requiring a person under arrest to be brought before a judge or into court, especially to secure this person's release unless lawful grounds are shown for their detention. And that's why there's certain amounts of time that are attached to that. Habeas corpus just means produce the body, bring me the body, right? You can file a habeas corpus for other things. This is just from Wikipedia. This is a pretty common legal thing. But it is good. Thank you for pointing that out, TY Pro, for everybody to check out. Let me see if I can jump back into where I was. Okay, so what was I talking about? We were talking about the joint approval. So the Supreme Court is saying, hey, the rules on the approval for special justices have been changed, so we need to rule on this case. They also point out that they set the briefing schedule for this case, is the next thing I wanted to point out. There's more in here too, guys. If you guys want to go in and really dive deep on any of these things I'm going to show you, we've got the links and you can do it. And you might find some other things more interesting than the stuff that I'm pointing out. There's a lot of legal argument here. So let me pop this back up. So here's the schedule according to the Supreme Court. The appellate's brief is scheduled to be no later than 15 days from the date of this order. The respondent's brief for both the National Council and Executive Branch is no later than 15 days from the date of the appellate's brief, and the appellant's reply brief is no later than 10 days from the date of the respondent's brief. So as we can see from the current docket here in this case, that the National Council's response and the Executive Branch's response have been filed on these days. These numbers at the end here are the dates they were filed, 10/7/2024. So the next filing in this case should be the reply brief, the appellate reply brief, and that should be in the court by 10/17/2024, so next week, and then that will be all the briefs will be submitted. After the briefs have been submitted, I don't know if they're going to have oral arguments in this case or not, but that's the timetable that we're looking at the 17th would be the earliest we would expect the briefs to appear on this page. But it's probably realistically going to be a few days after that. It took them a couple of days to get these briefs up after those deadlines were passed. So I was kind of debating about whether I was going to do this lawyered up, after everything was in there, or I was going to go ahead and do it now because it had been so long since we'd had any updates. And I decided to go ahead and do it because the reply brief from the appellant, Mr. Solomon Simmons has made his initial argument with his petitioner's brief that we're going to look at in just a second. And the reply is mostly him addressing arguments put forth in the respondent's briefs to try to give more information and so on and so forth. So it's not really going to be new stuff, right? But we are going to keep an eye on this case after that to see if oral arguments are scheduled or if they're just going to issue an opinion at some time in the future. So with that being said, let's go back into the paperwork here and let's start off with the petitioner's brief. So we're going to scroll down here. This is recapping the entire case. If you guys want to get a recap, you can either watch our previous coverage or you can read this brief. This is Mr. Solomon Simmons' brief, so keep that in mind. With his brief, the first thing he's pointing out is that the Constitution and the Code set up the MCN Supreme Court justices for 6-year terms. And he's saying that the reason that they were set up with these 6-year terms is so that they would have time to learn how to be a justice, right? They'd be able to grow into the position. And also that would help them be separated from any type of influence. The idea being they've been on the Supreme Court for a while and they've learned to insulate themselves from outside influence. So that's his first point. Let's go on to the next one, which is he's, and this happens several times in this brief, he's saying that these justices are picked because of how the legislative or the executive branch believes they will rule, right? We kind of pointed out some stuff like that with Mr. James Jennings and his previous statements. And so he's putting forth an argument here where he's saying that, let's see, where is it? I got to skip ahead here a little bit. So his argument is that the special justices are being, here it is. It says justices would not, or hold on, let me back up. Judicial power in the Mvskoke Creek Nation shall be vested in one Supreme Court. The Supreme Court shall be composed of 7 members whose term shall be for 6 years beginning July 1st. And then this is his assertions. The framers of the current MCN Constitution required justices receive a minimum of a 6-year term. Justices would not, like these special justices, be selected for how they would rule on individual cases, but for their general knowledge and wisdom. They would be insulated from outside pressure and would have time to grow into the role. So we talked about that already, but also this claim that justices are being selected because the executive branch and the National Council believe they're going to rule a certain way based on their prior statements is, that's an assertion made several times in here, but I don't see any evidence for, he's not presenting concrete evidence of Chief saying, or whoever, anything like that. He's just saying, he just asserts it, okay, just to clarify to everybody. What's next? I'm going through my notes here, guys. 3, procedure okay, let me scoot on down here to this part. So the next thing that he points out is that when the law was passed, let's see here. This is saying that it can be done. Yes. Okay. So the next thing that Mr. Solomon Simmons, it's not the next thing. There's some other sections in there that you saw where he is reiterating that this case could be heard. I'm not going to go through that stuff because it's mostly kind of like legal stuff, and they're going to hear it. That's been decided. But so this National Council actions violate its own procedures. Okay. So what he's saying is when they passed NCA 24-077, the instructions in there, sorry, I'm just trying to find the exact part. The instructions of the law, right? And I'm going to read it. The special justice law requires the clerk of the Supreme Court to notify the principal chief of a recusal. So the Supreme Court has to tell the principal chief there was a recusal. It says then the principal chief has to nominate a special justice. So he nominates a special justice. And then the National Council confirms the special justice by a majority vote. So what Mr. Solomon Simmons is saying here is he's saying they passed the law, and in the same session that they passed the law, they tried to confirm a justice, and there's no physical way that the procedures of the law could have been followed in the special justice law because it hadn't been passed yet. So there's no way that the Supreme Court could have notified the principal chief to do the nomination part, right? So what he's saying is they would have had to, let me pop myself back up. What he's saying is they would have had to pass the special justice law first, and then the clock would have started on all of the notifications. So then after the law was passed, then the clerk of the Supreme Court would notify Chief's office, and then Chief has an amount of time to nominate somebody, and then the council has an amount of time to confirm that person. But since they didn't do it that way, then that's a violation of the law that they were trying to pass. So that's the first thing that he's arguing. He also puts an argument here that the National Council violates their own internal procedures about how emergency sessions are called and those things. I'm not going to go into that too much just because I know from previous coverage that, the National Council can change the Constitution, the Creek Constitution allows the National Council to change their rules and procedures, their internal rules and procedures of how they conduct business, basically whenever they want to. So, like saying that they're violating their own thing is going to be, and proving it in court is going to be very difficult, as we've seen in prior things, because of that, the Constitution giving them that broad leeway of how they are to conduct their own internal rules and procedures. Okay, so let me go on down here. What's next? The next thing that he points out is Mr. Solomon Simmons wants to show that his claims are justiciable, and one of the ways he's worried that their other briefs are going to say this is not for the court to hear, which they do, and an interesting argument that he puts forward for that I don't know is really addressed in any of the other briefs, but we're going to go through them real quick, is that this statement here where he says the special justice laws impact ongoing litigation and call into question the constitutionality of the forum in which petitioner's case is being heard. So he knows that there are ways that lawyers could challenge the Supreme Court hearing the constitutionality of this law, right? And what he's pointing out is here that you guys have got to rule on this because there's cases going through court right now that this law affects, right? Which is keep that in mind when we're going on to the next briefs. And with that, let's go on to the next brief. We're going to be looking at the National Counsel's brief next, and this is Mr. Kyle Haskins, I believe. Yes, Kyle Haskins. Okay, so the National Counsel's arguments revolve around another previous ruling by the Supreme Court that I'm going to scroll down here to get to it. Just a second. Here we go. This one. So, while Mr. Haskins does address some of those claims earlier, you can read through there, and those are things are debatable. This is the crux of the National Counsel's argument about why this shouldn't be addressed, or if anything, they should rule that this law is constitutional. And let me pop myself up really quick, because I'm going to try to nutshell this stuff for you guys. This case that he mentions here, A.D. Ellis versus Shakota Mvskoke Creek Indian Community, right? There are two sections of code. One of them says that there needs to be a 4-justice opinion, right? And another one says that they need to have a quorum, right? In this other case, which let's just take a look at it really quick. Let me pop that back up. In this other case, we're going to go here to the Supreme Court's website again. We're going to go to opinions, and the one that's being referenced is in 2013. So we're going to go down to 2013, and we're going to click on this right here. This is what they're talking about. Ellis v. Shakota Mvskoke Creek Indian Community. So what this is there was a case that got decided, and the decision of the case constituted less than 4 justices. So after that decision was handed down and everything, the lawyers involved filed a order or a motion to vacate that decision by saying this part of the code says there has to be 4 justices make this decision, and there weren't 4 justices that made this decision, so you got to vacate this decision. It's no good. Okay? And what we're looking at right now is the Supreme Court issued an opinion and an order saying that, and this is the rationalization for it, it's really long, but basically Jonadev Chowdhury, who you guys know, he was on the Supreme Court at the time, and he's the author of this opinion and order, and he said that when you look at the code in totality, let me go down, I'm going to find the part here. Just give me 1 second, guys. Here we go. This is what I want. So in this opinion, he talks about the history of the legislation and the different sections. He mentions here construction, which reads 3-101 and 3-103 is functionally equivalent to the simple majority rule, also comports with the historical reality that the Supreme Court is required to decide most cases with less than 6 justices. In light of this reality, it would be nonsensical to construct 3-101 in a manner that ignores its history and interrelatedness with 3-103. The only constitutionally acceptable construction requires both sections to be read together and require only a simple majority of a quorum for Supreme Court decisions. A 3-justice majority is sufficient for a decision when only 4 or 5 justices are participating. Due process, sufficiency, and deference to the National Counsel's legislative authority dictate that we adopt this interpretation, okay? So I do want to point out one more thing, because he mentions here, up here, the number of decisions that have already happened at the time. This is 2013. So at the time that this order was issued, he quotes up here, let's see, where is it? The number of decisions that were made with less than 4 justices. Okay? Let's see here, where is it? No. I think it's right down here. Sorry guys, I should have had this footnoted. Well, it's in this order somewhere, but in a nutshell what he says is about 30% of the decisions up until now have had 4 justices in the majority decisions. And then 70% of them have been less than 4 justice decisions. Now the reason I wanted to point that out is because so this order maintained the status quo, right, for the precedent set by the Supreme Court. Okay? So they made decisions on how many justices it takes to make a majority opinion so that a lot of the previous decisions weren't thrown out. Okay, does that make sense? So apart from, he's saying that if you read all of these regulations together, it's obvious that they meant both things, that if you have 6 justices, you have to have a 4 majority, but also if you have less than 6, you need to have a simple majority. That's on the books as a ruling. But part of that reasoning is so that we can keep all of our previous precedent. Now I'm going to go back to the National Council's argument. So what they're arguing is there needs to be an update legislatively to fix this issue, because their argument is the less than 4 justices to make a decision is wrong, right? Basically, they don't come out and say that, but they do cite dissenting justices' opinions and things to say that basically they're saying the National Council believes that there should always be a 4 justice majority opinion. And that's why we passed this law to have these special justices, is so that we can have any case that's in jeopardy of having a 4 justice opinion, we can appoint special justices so there's the right number, so we can get that 4 justice opinion, which makes a lot of sense as far as why they did it. But here's the problem. If the Supreme Court decides in favor of that, right, all of those 70% of cases that didn't have 4 justice opinion are going to be no good. It's a bit of a problem. Okay, what else did they say in their arguments? Let's see here. Let me pop this up again. Yes. Okay, let's move on to the executive branch briefs. So, this is the executive branch filing. And you can see there it's Rod Weimer and Joseph Williams. Rod Weimer's name is known here in the tribal court for many years. What's the arguments here, though? Number one, he's putting forth this basic thing. This action is non-justiciable as a political question. What does that mean? Okay. So what that means is there's like a kind of like, I don't want to say it's a rule, but it's the idea that if the legislature and the executive branch in the United States pass laws that are related to policy questions to address policy issues, the judicial system shouldn't go back and hear those policy questions or those policy issues, because those were political questions that were addressed by legislation, right? It's kind of, there's a bit of an explanation in here, but it's kind of a convoluted argument that basically says you guys can't hear this case because this is about the policy for how the court justices are nominated and confirmed, and you guys shouldn't have any statement of that. He also goes on to point out that the same thing that we were talking about with the National Council arguments, where this brief states that the executive branch would prefer the construction of the system to have always have a 4-justice opinion, right? Instead of this minority, or the 3-justice opinion that's a possibility, that as how the system was before this law. And then also it addresses, if you remember when we were reading the Supreme Court's order to assume the jurisdiction for this hearing, or for this constitutionality challenge, they mentioned that the Chief Justice of the Supreme Court used to have the ability to have some say in special justices, who they were and how they were appointed, right? Is that part of the process, how it used to be before this law, and that got removed from this law. And how they address it in this brief is that, let me go on down here to find it. That's the intrusion into the... Just one second, guys. Here we go. Oh, I went too far. Where is that? Did I make a note on that? Here it is, page 11. Sorry, guys. Got to go to page 11. Okay, this is where they talk about it. This court cannot complain that the judicial branch has been effectively removed from its role in making temporary appointments to the Supreme Court when that role was granted by the National Council and Principal Chief through legislation. What was granted by legislation can be removed by legislation. Okay, sorry, I didn't realize I was up on that. Let me pop that up for you guys. This argument is basically saying, well, the ability that the Chief Justice had to have some input on special justices was an ability that was granted by the executive branch and the legislative branch, right? And they can take that ability away whenever they want to, which technically is true. I don't think that it's really addressing what the Supreme Court is pointing out, though, because he's saying technically we can do it. What's the big deal? And the Supreme Court was saying the big deal is, like you're removing us from the process, and there is previous legislative intent with the way the law was before for us to be included. So we need to take a look at this. I don't know which way that's going to go, but that is interesting that those two things were pointed out. So let's keep going. Then the other argument that's put forth in the executive branch's brief is this concept of, let me back up here a little bit. The Supreme Court is violating the canon of constitutional avoidance. So the brief is saying there is this canon of constitutional avoidance, which says that let me back up a little bit. The Supreme Court, and it ties into things that the United States Supreme Court has established as how they operate. Let me see if I can find the exact phrase I'm looking for in here. Just one second, guys. I think I went too far. That's Constitutional Act. It's past that page. And then he points out some. Separation of powers. Oh, I think it's right up here. Okay. So the constitutional avoidance issue is that courts should avoid determining constitutional issues unless absolutely necessary to a decision of the case, and they shouldn't pass on a constitutional question, although they need to have some reason to issue a decision on whether a law is constitutional, right? Otherwise, they shouldn't do it, and they shouldn't rule on separation of powers, kind of like along the same lines. It's a principle that I think the idea with it is that you don't want individuals in cases to challenge the law structure behind what they've been sued for, they've been charged with, or whatever, by saying, well, you can't charge me or do this because that's unconstitutional, and then the court has to automatically hear the constitutionality of every law, right? That's where that comes in. They're trying to keep that from happening. Unfortunately, in a lot of this argument here, it doesn't address that claim that I pointed out in Mr. Solomon Simmons' brief, where he says there's a case in court right now that this law affects, right? And that's the problem, is one of those things that says they have to hear these constitutional challenges is when there's an absolutely necessary to the decision of a case. So whether these special justices can be appointed to the case that's being heard is necessary to determine whether this case can be heard, and what the decision of the case, moreover. Okay. We've gone through all of that. Let's if you guys understand it better than me, let me know. But that's how I understand it. Okay, so we're at the wrap. So what is the wrap? The wrap is, we're at 30 minutes. Good. We still have a brief that should be posted sometime after the 17th. That will be Mr. Solomon Simmons' reply to the National Council's brief and the executive branch's brief. I would expect, if they're going to have oral arguments in this case, that it would be posted on the Supreme Court's website or somewhere. There would be some type of announcement made. And I think there's a possibility that could happen just because they had previously scheduled the oral arguments for the other case that this is related to here, the Citizenship Board of the Mvskoke Creek Nation versus Rhonda K. Grayson. That case was going to have oral arguments, and then this challenge put a stay on that case. So I think that they would probably, if want to have oral arguments in this, maybe, I don't know. There does seem to be a lot to argue about in whether this is constitutional, but we'll keep our eyes open for that. T.Y. Prohl in the chat made some suggestions for some more lawyered ups, and I'm going to look into those, and we might have a lawyered up in the next couple of weeks. In November, for sure, I'm going to be doing a lawyered up where we go down a rabbit hole on a case that's at the 10th Circuit Court of Appeals, I think it's 10th Circuit, between Tlatelolco Tribal Town and justices of the Mvskoke Creek Nation, right? That has a bunch of twists and turns, and it goes over 10, 12 years or whatever, but we're going to go down that because the oral arguments for that case are going to be heard at the end of November, and I'm going to live stream all that, so we'll do a catch-up. It'll probably be in the middle of November or so. And then what else? I went to the oral, if you guys watched the oral argument live stream with the porch ban case, I went to on the trip to the court and was running the live stream for the press conference. And if you didn't know, if you tuned out when the oral argument stopped, there is a press conference at the end of that live stream with everybody talking about what's going to happen, okay? We don't have a decision there yet, but we're keeping an eye on it. And as soon as something comes out, we'll let you know. There's some other things I'm watching. We still do not have a decision in the Strobel tax case from the start of this year, but surely maybe that will be coming. And there's a question popped up here from T.Y. Pearl. He's asking me, what is your Halloween costume this year? You know, and along those lines too, I'm trying to figure out something to do for Halloween. If you guys have any suggestions, I'm talking about programming for the YouTube channel. You know, we normally try to do a Halloween program of some kind. I don't know if we did one. I don't think we did one last year, but the year before that, and so on and so forth. And I'm just running out of stuff. You guys know of a haunted house or something spooky or something we could do, let me know. We don't, to answer your question, T.Y. Pearl, right now, I don't have a plan. I'm working on it. But if you got any suggestions, hit me up. My Halloween costume this year is, I got this mask that's like, kind of like, looks like the Man in the Iron Mask. I'm going to be like the Man in the Iron Mask. And if that doesn't work out, I've got a backup costume. It's like a generic Grim Reaper costume. So that's what I'm doing. Why Jesus? You know, like you need to disambiguate that white Jesus, Indian Jesus, and so on and so forth. So, but it was great talking to you guys. It's been a while since we had a lawyered up, and we're going to have another one in the future. Next week on the Monday, we're going to live stream the Indigenous Peoples Parade from downtown Tulsa if you guys want to go get in the live stream, and then it's going to be on here. And then on Thursday the 17th, which is the same day those briefs are supposed to start dropping, we are going to have a live wire about the Shell Shaker play that's going to happen in OKC. So if you're interested in that, tune in there. Miss Teresa Gold says, we need a history of the Creek freedmen such as slave schedules if you want to be informed. I will check that out. So, but with that being said, thanks for tuning in, guys. I appreciate you, and we'll have more in the future. Mado, Chihichat, please.